morning, everybody, and welcome to Law and Crime. I'm Jesse Weber, joined here by attorney Terry Austin. We're going to break down the biggest live trials and legal stories in the news today. We are going to be live in two major courtrooms, so we have a lot to discuss. Let's get started. Okay, the prosecution delivering their closing argument right now. Now, Terry, there's a lot for them to consider, a lot for this jury to consider, a lot of moving factors, a lot of players, a lot of motivations. How do you think she's doing at summing it all up?
I think she's doing a really nice job. What I like is the fact that she's calling Vorpagel Charlie. She wants the jury to think he's a good guy, he's telling the truth. He could have just not cooperated, but he did cooperate. And she's calling the defendant Vasata, and I think she wants the jury to look at him as though he's the bad guy, along with the other co-defendant, Stewart, who's being tried separately.
Do you notice that when they say Luke Kasukis, who's this other third party, they're indirectly mentioning his involvement, saying, we know that right now this trial is about Vasata. Marcus Stewart's going to face his own trial. And if there's a third party, they may face justice later in the future. But I have a feeling the defense is going to jump on that in their closing.
Yeah, it's interesting because they haven't said a lot about him, but they keep referring to him. So it's unclear what his involvement in this whole situation was.
Yep.
It seems like Stewart shot and Vasata got shot, but what did Luke do?
That's a good point. I'm sure the defense is going to jump on that, and this is just one side of a very complicated story. Now, she's making a good point here that the defendant, he gets shot. First thing he says is, oh, I was at my friend Charlie's house and I got shot. That wasn't true. And then he gets dragged away. Why would he be the only victim dragged away? Something doesn't add up. What do you think?
Exactly. He was dragged away because they were trying to get away. And I think, you know, she's trying to make it seem like he's not an innocent victim of a shooting. He was part of the shooting. What
happens if he went there and she says, look, do you think he really went there to make peace and try to ease the tensions when he's armed with a weapon? But let's say he went there to make peace but just had weapons to protect himself. He didn't know there was going to be a shooting, and he's caught up in this, and then he gets shot in the middle of it. Is he still responsible for what happened that night?
Absolutely, he's responsible. He's there on the scene, and there is a huge crime. There are people who are killed.
Right.
He's, you know, a co-defendant in this.
All right, well, you're hearing how the prosecution's laying it all out. Okay, prosecution just finished up. What do you think?
Great closing argument. If I'm sitting on that jury, I'm thinking he has premeditated murder. They came in ready, willing, and able to shoot. They had these assault weapons. I think she did a great job.
And now they have the option of second-degree murder or manslaughter. It just made the radius of responsibility even wider. So let's go back live. Defense is delivering their closing argument. Okay, so let's break this down. Now, Terry, let's start with where she's going right now, really casting blame on Charles Vorpagel. That, can you believe anything this guy says? He says that the defendant wasn't his friend and that he wasn't at the party, and that really what was going on in his life in terms of conflict and competition. Is that important? Is she striking the right chord right here?
I think she is, but I don't think she's going to win over the jury. He was afraid for his life.
Who's he?
Vorpagel. Yeah. He went running. It's his house. He went running out and over the fence and to someone else's house and asked them to call 911. I mean, he actually was afraid for his life.
That's a good point. The other part of what she was saying was that you need to prove that the defendant intended to kill somebody that night. That he went in there with an evil heart, reckless disregard for what happened. Is she right? Is she accurate on the law here?
Well, the prosecution doesn't have to prove what his motive is. They just have to prove beyond a reasonable doubt that he is an accomplice. And the fact that he was on the scene, he's with Stewart, guns are blazing, he just happened to get shot.
Is that enough? Is that enough?
We'll see. I think she's making the defense a decent argument. She's putting doubt in the jury's mind, for sure.
Yeah, I mean, there's no doubt that he was there. He got shot. The question is, what was he thinking before? What was he doing during the shooting? And the fact that he may have been lying afterwards and saying he was just an innocent house guest, when really that might not have been true, that doesn't help his situation. So there's a lot more that we have to look at here, and we're going to have to take a quick break. But when we come back, we're going to hopefully jump live. We're going to hear the conclusion of these closing arguments. We don't want you to miss anything because this is a really important summation to this entire case. Who will the jury believe? Have to wait and see. All right, lot to break down right now from the defense's closing argument, or part of the defense's closing argument. So I'm joined here, of course, with Terry Austin, our attorney here on set, but also I'm joined by forensic death investigator from Jacksonville State University, Joseph Scott Morgan. Joseph, good morning to you. I want to start with you. Okay, so this is a complicated crime scene, lot to break down, including one of the things the prosecution said was that Sean Henry was shot so many times that clearly he was one of the intended targets, and that's why this looked like an execution. What's your point of view on the crime scene?
Good morning. First off, thanks for having me. Yeah, the idea here is that this is very complicated. This individual was shot somewhere in the teens, I think, is what the Dr. Just said relative to the injuries that this individual sustained. So yeah, for us that kind of explore these types of things, that would give us an indication that the individual was targeted. It's rare that you're going to find somebody that is shot multiple times by accident. So that would give us an indication there. And we've got a myriad of physical evidence in this particular case, Jesse. All of these casings that are at the scene, multiple weapons, these sorts of things, and just spread about over the landscape here, and not to mention the evidence that comes from the bodies that gives us things like range of fire, the physical attitude of the individuals that are shot, and this sort of thing. So you need a deft hand to try to interpret this. Yeah,
that's very well said. And Terry, look, even if his DNA, the defendant's DNA, is on these pieces of evidence, and even if he was shot and he was there, what the defense said is, how can you prove he did anything other than try to negotiate that night and try to make a truce? What's the counter argument to that?
It's interesting because when I listened to the prosecution, I thought, good argument. And then when I listened to the defense attorney, I thought, good argument. I probably wouldn't be a good juror. But I think the fact is, when Vasata was shot, she's trying to say, the defense attorney is trying to say he didn't have the intent when he went there to kill. And the prosecution has to show elements of the crime, that there's an intent and a causation. And she's trying to say they're all friends and he did not intend to kill anyone. And he, in fact, himself was shot in the back.
The other side of it is, why was he wearing or allegedly wearing dark clothes? Why was their car parked so far away? Why did it appear to be a sneak attack? And why did it not appear to be someone who was just going for a good faith meeting? Now, Joseph, DNA is a big part of this case, and his DNA was on key pieces of evidence that was found in both the BMW, in his pockets, and also, the weapons that were allegedly used. What's your take on the DNA in this case?
It's hard to get, for jurors in particular, I would imagine, in this world that we live in, it's very difficult to get past just the numbers that are involved with DNA. I've said this before with you. When you start talking about 1 in a billion chance for things to happen, and specific identifiers and all of that sort of thing, it gives one pause. But again, going back to what our colleague said, this does not necessarily go to intent. And just because DNA is there, intent is such a higher order here in what they're trying to prove. My suspicion is that they're looking at this and casting a wide net and saying, well, yeah, we'll try for a higher level of homicide here, but we've got some others down the road that we can that aren't so difficult to improve intent with.
Yes, and I want to get to that right after the break because the jury has a lot of considerations, a lot of options here, and we're going to break down what those options are. Terry, I got to tell you, how important was his testimony? Because he didn't positively identify any of the shooters, said they were wearing masks at one point. There are no masks that were recovered. So you tell me, was he an important witness? What should we be thinking about with Charles Verpagel?
The only thing that he can add as far as his testimony is concerned is that Vasata was not invited to the party, I guess, the July 4th event. And so,
Super Bowl.
Or Super Bowl, that's right. And so since he wasn't invited, he clearly was not a friend. So he's adding that, but his whole demeanor and his answers aren't really adding a lot of value.
It's interesting. And look, you know, Joseph, this is a complicated case. We keep talking about it, but the idea of having these multiple victims, two young women who are not even involved in this apparent conflict, but one of the victims, Sean Henry, who was allegedly part of this conflict and a part of this drug trade. What does that tell you about the victims, the level of shooting? I mean, what should we be thinking about the killer or killers?
Well, it's not something that you know, that they're obviously practiced at. They didn't go in just kind of individually targeting this guy. It was kind of you know, I hate, it's not kind of crass, but spray and pray kind of thing, where they go in and you have all these poor peripheral people that have nothing to do with this event who are killed, and you know, I think that you know, they talk a lot about the gentleman that was allegedly targeted. I hope that they're going to factor the lives of these two young ladies into their final determination in this, because it's very tragic.
Yeah, well, I'm sure that they will. And right now I'm getting word that we can jump back live into court. Now, where we last left off, I believe this is still the defense. It's the defense providing the second half of their closing argument. I think this is all going to be about the evidence. Let's go back live. Okay, so this is the second half of the defense's closing argument. Is he the law guy and the first attorney was the fact person? I mean, how are we why did they divide this up?
That's the way I would separate it too. He's talking generalities. He's giving the high level picture. He's talking about elements that could be discussed in any trial, frankly. So the way I guess they decided to split it up is the first defense attorney would talk about the specific facts of this case, and he would then come in and talk generally about the jury, about the evidence.
Yeah.
And so it's very general.
It's an interesting strategy. And Joseph, one of the things we just heard was about how the defendant was shot. Now, based upon the location of where he was shot, and according to the defense, he was carried away because he was a victim. He was carried away. Prosecution wants to say he was taken away by his co-accomplices. What do you make of that, how he was shot and during the course of these events?
Well, obviously he's in a position or in a physical attitude where he's turned away from the muzzle because, you know, according to reports, these are both entrance wounds in his back. I think he was shot twice, if I'm remembering correctly. So that gives us an idea that he's moving away at that point in time. Now, when he is removed, who can say if it was an escape or if it was an attempt to render aid? And again, you know, we're in a position here where, you know, how many angels can we get to dance on the head of a pin in this particular case? So that's kind of interesting. You know, is it a planned escape, or are they just trying to render aid? And that's something that that as he's presenting it, that and as the prosecution is presented it, that the jury is going to have to make a determination on.
Listen, Joseph, that's a great explanation. I thank you for that. I also thank you for giving me the best slogan I think I've ever heard in my entire life. How many angels do you get to dance on a pin? I'm going to be using that. First, I want to look it up because that went right. That was amazing. Let's take a break. I'm going to look up what that means, and we're going to be back live in a minute. All right. So as the defense is delivering their second half of the closing argument, I think we have some questions. And Joseph, I want to start with you. He is poking holes in the prosecution's case, in the evidence that was presented. Your thoughts as you're listening to this?
A lot of people, I think, try to make quite a bit of hay out of pattern distribution of ejected rounds. This particular platform of weapon, as he was talking about, ejects to the right. And it's a very dynamic event, Jesse. He talked about movement, the you know, kind of the angle or the attitude that the weapon is in as it is ejecting these rounds. And it's what he didn't talk about is that it's heavily dependent upon the surface which these rounds are landing on. If you're on a paved surface, the rounds or the casings have a tendency to bounce and to go other directions. However, if you're on a grassy surface, many times those spent casings will stay approximating their original location. unless they, of course, hit something that's laying within the grass. So it's not going to really, convolute the picture at all relative to where these things come to rest on a grassy surface.
That's an interesting thought. And I guess the other part about it, Terry, is he says when you look at what non-speculative evidence do you have that the defendant directed Lou Kasukis to fire any of these weapons? I mean, this concerted effort, this conspiracy to engage in this ambush. I think he makes a good point. What do you think?
He makes a good point, but what the jury has to think about is why was Vasata there?
Right.
And the fact that he is an accomplice to this, regardless of what was thinking right then and there as far as the shooter was concerned. So he's there. The shooter may or may not have intended to be shooting when he came in, but the fact is it all went wrong and Vasata was there, so he's going to be implicated in the crime.
And without a key eyewitness other than Vorpagel to say, well, these are how the shooting took place, this is who shot who, this was the manner of shooting, we don't have that. We don't have it on surveillance footage. We don't have a key witness. Some of this is speculation. It's just who's presenting a better case. We'll take a quick break. We'll be right back.